I have a question here that says, I rented a garden flat. I paid the full deposit and 1 month's worth of rent prior to moving in. No entry inspection was ever carried out. I had no contract with the landlord and I paid rent via EFT, but did not receive a receipt from the landlord. On the 4th of August this year, I gave notice as I could no longer afford the rent. I moved out on the 27th of August. Before leaving, I requested that an exit inspection be carried out, which was refused by the landlord. A time for the inspection was set, but I could not attend due to transport constraints. So sorry, it was refused when I wanted it, but it was then set for a time where I was not available. The landlord now refuses to refund my deposit, saying I must take them to court. I did take photos of everything, meaning the condition of the property after I cleaned it. And further to this, I discovered that the deposit wasn't invested in an interest-bearing account, and the landlord did not declare the income from the flat to SARS. What are my rights in this regard, and can I approach the small claims court? Cilna?
Chris, this viewers gave us basically a list of questions that can keep us busy, like the entire, we can do this for this one episode. So let's start at the very beginning. And I'm going to try and break it down. So Bruno, please let me know where I've dropped. Okay, so will you be the, Hansie and Grietjie pick up the breadcrumbs as I miss it. So sure. The starting point is actually, the question says that there was no lease agreement, but no contract between the landlord and the tenant. But there was rent paid and there was deposit paid. Now, very important is a lease agreement does not have to be in writing. The Rental Housing Act requires a lease agreement only to be in writing when the tenant requests the landlord to reduce it to writing. Other than that, the parties are allowed to contract verbally or even tacitly. And to be quite honest, there must have been some other verbal agreement between this landlord and the tenant. You don't just randomly move into a property and EFT money, luckily, into the right banking account. And if you have that kind of powers of knowing, feeling banking details, call me. I very often need to find banking details if I try and collect rent for clients. So it's unlikely that there wasn't any formal communication, even an email to get, or a WhatsApp to get the banking details across. The parties agreed to the property. They've agreed to the amount of rent. They've agreed that the tenant will have undisturbed use and enjoyment of the premises, and that ticks all the boxes of the essentialia of a lease agreement. And for that reason, there was a lease agreement in place, even though it was verbal. Just a side note, the Rental Housing Amendment Act, which hasn't been promulgated yet, would require lease agreements to be in writing, but that was already published on the 15th of November 2015. So I don't see that that promulgation just suddenly happening. We're going to have to wait and see, but once that is promulgated, a lease agreement will have to be in writing, but still, as the tenant, you will have the benefit of the landlord's failure to conclude a lease agreement. So it won't just be like, nah, there was no agreement signed, not in compliance with the Rental Housing Act, so okay, I'm just going to stay here for ever and ever. It's not going to be like that, but it's important to keep that in mind. So with this having been said, there was a lease agreement concluded. The tenant performed in terms of that agreement, that verbal agreement, by paying the rent and the first month's deposit. Now, the Rental Housing Act regulation, not the Rental Housing Act, the regulations to the Rental Housing Act, Regulation 4 specifically says, if a lease agreement wasn't signed, but the tenant paid the first month's rent and were allowed to take occupation, that is deemed to have been signed and delivered to the other party. So the regulations tell us this contract was fully concluded. The Act also requires inspection. The problem is, the reason for the inspections to the premises is actually more to the benefit of the tenant than the landlord. When used correctly, it is very much to the benefit of the landlord. But what the Act says is, if there was no inspection concluded, it's deemed that the property was in a good condition. However, if the tenant did not, if the landlord refused to have this inspection, there would be no way of proving that the property was in fact in perfect condition. So there's no way of proving that the tenant is responsible for defects and damage to the property. So the landlord effectively loses his entire claim for damage to the property by not doing an entry inspection. Then on the exit inspection, the fact that the parties agreed to a time and a place and the tenant didn't arrive, even though the tenant might have had a good excuse, the Act says if there was an inspection arranged and one party does not attend the inspection, the other party may do the inspection, record it complete, and it would be deemed that both parties were present at the inspection. So this is very important also for our other viewers to keep in mind. If you are the agent or you are the landlord and you struggle to get hold of the tenant and you finally get a date and a time for the inspection, you get there and the tenant doesn't pitch up, you can do the inspection, but my advice on that is take every single photo in as much detail as you can, record your full inspection properly, and you would still be able to then deduct all the damages from the deposit. Now, in this particular scenario, I think it wasn't done on either side properly, to be quite honest, and I'm sorry to be frank, but I think it's important for tenants to also be aware of this. You also have a responsibility to attend the inspection if it was arranged. And if you don't, unfortunately, the landlord may proceed without you. And it's then deemed that you have been present and agreed to everything. The fact that this landlord is now keeping the full deposit, this does not make sense to me, because the problem is there wasn't an entry inspection. If there was an entry inspection, an exit inspection that reflected some damages, the landlord would have been able to retain some of the portions of the deposit, but only to the actual value of the repairs. And remember, the deposit has to be refunded if there's no damage within 7 days from termination of the agreement. And if there were damages, within 14 days of restoration. And then there's a requirement on the landlord to provide the receipts of the repairs to the tenant to reflect this was what was done, this is what we've deducted, and then you have to refund the remainder of the deposit. So as far as the landlord's retaining the full deposit, that doesn't sound right at all, especially considering there was no incoming inspection. With regards to the deposit not being declared to SARS, I am a little concerned as to how this came to the tenant's knowledge without contravening some privacy rights, but be that as it may, it could be that you're a SARS official and then, you know, but regardless of how that happened, keep in mind that your deposit isn't seen as income to the landlord. So it's not an income taxable thing. You have to keep that money, even if it is in your normal account, as long as it is with a financial institution, carrying a minimum interest rate of what you would get at a normal financial institution. So not Luna, we can't invest deposits in Bitcoin or other cryptocurrencies. That does not tick the boxes at all for the requirements on the Rental Housing Act. But as long as you can show that there was interest, minimum interest, as you would get in a savings account, happy with that. But the fact that it wasn't declared to SARS is really irrelevant to the conversation, for the simple reason that it isn't a taxable income, because the deposit that the landlord received isn't an income. It is money to be held but it still belongs to the tenant. Ownership of that only transfers at the end when the receipts are delivered and the money is now going to the landlord. Whoa! Did I get almost everything, Bruno? How many crumbs did I leave?
Almost, I think maybe 3. So good job.
Well done, Bruno. Well done.
Okay. It's because I'm almost older and wiser.
Bruno, can we hear about those crumbs?
Okay, cool. So, but it's very small stuff. Cilna dealt with whether the agreement needs to be in writing or not. She dealt comprehensively with the inspection, so that's a big one in this case. The deposit being invested, she also dealt with now, so that's actually a crumb she dealt with right at the end. The only variation to the answer is with respect to the retention of the deposit is if this lease is being terminated early. I didn't actually get that from the question. It feels like it was a long time ago. So if it was an early termination, then the grounds for retention could be more than just damage to the property. It could be the argument that, you know, they didn't give proper notice, or that there were still time periods left on the lease, or something along those lines. Obviously, the lease not being in writing makes it very difficult. So another thing that I'd consider is the fact that the lease wasn't signed may differ from the lease not being in writing, because there could be a situation where the lease was engaged upon, the parties were aware of the terms, but they simply didn't sign it, meaning that the terms are recorded somewhere, and, you know, certain provisions could be in there. So, you know, and that's the difference between a tacit lease agreement where a person moves in, pays the amount, and they're a tenant, and like the industry norms of a lease apply, where arguably, you know, it could even be a month-to-month lease, or maybe there were terms that were agreed to tacitly accepted by the person moving in. So yeah, that could be another reason for the retention of the deposit. And I think, yeah, I think the last thing was with SARS. I agree with Cilna. It's a very strange like fact to kind of stumble across. So short of a landlord actually admitting that they don't declare their rent to SARS, they don't declare their income to SARS. It's a bit of a weird one how they're sure about this. And sometimes I find that certain presumptions are made. So just be very careful before you start rocking the boat. But to add on what Cilna says, the income, so the actual rent would have to be declared to SARS, the deposit not. So, but yeah, also remember that you only declare your income at a certain point in the year. So you don't do it on a monthly basis. So it's only when you file your returns. So if this was a recent incident, it's unlikely that anyone would have been filing returns regarding this rent, at least during the course of this year.
Thanks, Bruno. Thanks, Cilna. Just one quick question with regard to the SARS information. What good would that do for a tenant in any event? I mean, what could they use it for? What would they do with it? Doesn't sound like something that could be used by
revenge. It's revenge. It's just getting someone into trouble. Yeah.
I wanted to say extortion. I wanted to say extortion. Like, I mean, but I don't think it's the wisest move to commit a crime because your landlord irritated you. I would be a little, you know, nobody looks good in like solid orange jumpsuits.
Speak for yourself, Cilna.
I look good. With the bald hair.
No, I'm sorry, guys. I'm way too pretty for jail. I'm sorry. I don't do orange.
Oh, guys, thank you for that.
Maybe just to actually wrap up, because the one thing we actually forgot about is the question is very loaded. Recourse, small claims court, yes. Rental housing tribunal, yeah, a better idea, because they actually deal with this, and they've got the processes, and approaching an attorney for a deposit will probably land up being quite expensive. So I normally ask the clients that are tenants that if it's just a claim of a deposit, rather go to rental housing tribunal. It's less expensive.